Okay, well, looks like we've stabilized here. We have 47 attendees. I just will be turning this over here in just a moment to Mike Rigby. But before I do that, I'll introduce myself and the other members of the ECMC team. My name is Mimi Larson. I'm the Deputy Director here for Policy and Administration. And we're assembled here today to present to you about the ECMC staff's proposed geothermal rules. We noticed the rules for rulemaking last week, and at the end of the presentation today, we'll walk through the calendar and what it looks like for our rulemaking schedule. But we want to start off first with a presentation from staff walking through the rules, giving you a good sense of what the rules provide for. And we are happy to take questions from stakeholders, but we're going to ask that you please hold your questions until the end of the presentation. I'll turn it over briefly to Ben Boudreau to introduce himself, and then we'll turn it over to Mr. Rigby.
Thanks, Ms. Larson. My name is Benjamin Boudreau. I'm an Assistant Attorney General at the Colorado Attorney General's Office. I represent ECMC, and I've been working with staff on getting the draft rules put together.
Thanks, Mimi and Ben. To introduce myself, I'm Michael Rigby. I am the ECMC's Geothermal CCUS and Underground Gas Storage Programs Coordinator. And I've been working with Ben and others here on the draft rules, and I'm going to walk through some of the rules and talk through some of what was noticed last week. And I'm going to try to share my screen here. Let me know if you're seeing the presentation. All right, good deal. So let's get started, and I can kind of walk through these rules. And I think I'm going to start with a bit of a short little background, then get into permitting and some of the different procedures there, and then talk a bit about geothermal units that we have in these rules. Talk a bit about operations and reporting for ongoing operations. Talk a bit about protection and safety regulations in place. Then a bit about financial assurance, and then I'll probably kick it back to Mimi to kind of go through the rulemaking timeline near the end of the presentation. So just a little background. Last year, SB 23-285 granted the ECMC authority over deep geothermal operations. So what are deep geothermal operations? These are generally operations that utilize non-tributary geothermal resources or any geothermal well deeper than 2,500 feet. And this includes those assessing or accessing tributary resources. So it's deeper projects. Non-tributary waters are generally waters that are not connected to the surface in any way. And tributary waters are surface waters, and those waters that kind of feed into streams and are interconnected with surface waters. So DWR retains all authority over shallow geothermal projects that utilize tributary resources, as well as any consumptive use of water in geothermal projects. So what this does is it leverages the expertise of the ECMC with deep drilling operations, as well as subsurface property rights. Deep geothermal resources are a private property right. And then the DWR retains authority over shallow operations, which are aligned with their expertise with shallow kind of water well permitting, as well as their expertise in water rights and water usage in the state of Colorado. So to dive in a little bit more into the Geothermal Resources Act, there are definitely some items that are required in any sort of permitting of geothermal resources in the state. It includes to safeguard life, health, property, public welfare, the environment, including wildlife resources. There is a statement to encourage the maximum economic recovery of each resource and prevent its waste, as well as a requirement to protect associated correlative rights. In addressing these kind of statutory requirements, we drafted what is the 1300 series. And while it does reference out to different rules and other series in our rules, they are all located within the 1300 series so that people can go to one place to see everything that's applicable to geothermal rather than it being scattered throughout our rules. Of note, just generally speaking, in the 1300 series, there is a default administrative process for permitting that does not require a hearing, but there are certain situations a hearing can occur. Additionally, there are science well rules for permitting in the 1300 series, which mostly reflect the strategies in the standing order that's currently applicable to stratigraphic wells. So kind of moving into permitting. Let's talk a bit about notice and consultation because there's quite a bit of this information in the rule set. There is required pre-application consultation. And this is similar to the process we informally do for oil and gas, but it's within rules. It brings together all impacted agencies and parties, kind of, or at least all impacted agencies like CPW, State Land Board, Division of Water Resources, EPA, and in the case of federal lands, potentially BLM, into a pre-application meeting to make sure all these considerations are done up front. There is notice to nearby members of the public. So all of the impacted surface owners by the facilities or the operations, all building owners and tenants within 2,000 feet are noticed, as well as schools and daycares within 2,000 feet. And as I said, there's required notice and a consultation process for different state and federal agencies, including public water systems, CPW, CDPHE, State Land Board, DWR, EPA, and just a flag here, notice and consultation with federal and tribal geothermal resource owners. It is not in the current draft, but it will be added. We noticed it wasn't added, and it will be added for let's say wells that are on state lands that interact with federal or tribal resources. And then I want to talk a little bit about local governments. So local governments in 23-285 also gained authority to make their own regulations for deep geothermal operations, or at least the surface siting of those operations, very similar to the authority for oil and gas. And then on our end, there is requirements for the applicant or operator to inform the ECMC of the local permit status, as well as consultation with the local government on the permit. So on our end, we'll be reaching out to local governments and talking with them, as well as being informed by the applicant the status of the permit. And then the local governments themselves can promulgate their own rules for the siting of these facilities in their jurisdiction. All right, so moving kind of into some of the requirements and plans of the actual permit. So for those of you familiar with oil and gas permitting, you're going to be very familiar with the Form 2 and 2A. The Form 2A is essentially the surface permit, or it's the location permit. And for geothermal, there's a variety of requirements. There's requirements to outline the different site equipment that will be used, have site drawings, site photos, different process flow diagrams, as well as details of how the geothermal resource will be utilized and how in that end use. So geothermal is a little different than other types of operations in that it can be utilized in a variety of ways. So will it be used to generate power and feed the grid? Will it be used for the direct use of the heat? Also, will it be used for power, but not to the grid? So maybe behind the meter type power projects. And this is all required to be submitted as part of the surface location permit. for an understanding of the details of how these things will operate. Further, there is a DI community, a disproportionately impacted community map and plan required. So this will map the project's relation to any DI community, as well as provide a plan on how to avoid, minimize, or mitigate any adverse impacts to the DI community. There is a wildlife map and plan required, very similar to oil and gas operations, and in this consultation with CPW will occur if there's any sort of impact to a high priority habitat. There's also geologic hazard map and plan required to identify any hazards up front, and an emergency spill and response plan. So in the event there is a spill, to have proper response plans in place, as well as coordination with local governments and authorities as necessary to respond to these incidents. There's also topsoil, stormwater, and reclamation plans, very similar to oil and gas, as well as noise, light, odor, and dust mitigation. So many of all these plans are in place to reduce impacts, and a lot of these were put together with our pre-existing work and knowledge from oil and gas operations and lessons learned with those operations. So moving on to the Form 2. The Form 2 is the actual wellbore permit, so the downhole portion of the project. So what's happening in the subsurface? So within that permit, it's required distances to buildings and infrastructure, a variety of technical plans and diagrams for the wells for our staff, as well as the public to have an understanding of where the well's going, what's the drilling plan, what's the type of casing and cementing being used throughout the wellbore. And all of this is to ensure proper wellbore integrity and to ensure we identify any associated hazards. It may also include an offset well evaluation if the well is near other wells of other types like oil and gas wells. So full subsurface evaluation of similar to what we do for oil and gas again, with all these plans. Something a little beyond what we've done for oil and gas is the details of injection activities, because many of these projects may have an injection well. So in the case that they do, we are requiring further information particular to the injection wells and data to inform how the injection activities can occur in a safe and protective manner. And then lastly, at least on this slide, is whether the well is subject to 1041 regulations, which are areas of state interest. All right, so kind of moving forward to talk a little bit about geothermal resource units. And this is a very, at least a similar concept to both how drilling and spacing units are, as well as our unitization process that we have in place for EOR operations. So these kind of is a similar process of setting up a unit to protect the correlative rights of all property owners that are impacted by the operations. In our rules, there is a high preference for concurrent permitting of the unit with the location and well permit, the 2 and 2A. And this is because we want the unit to be informed by the actual work that's going to occur. So what wells are going to be used and what resources are going to be accessed, and the unit should be set up based on actual planned activities. And this process is to facilitate multiple owners into a single project. And it's intended to protect the correlative rights of all impacted geothermal resource interest owners as required by the statute. And then further, there is requirements for equitable compensation for all resource owners and requirements for operators to make good faith offers to any unleased resource owners. Kind of diving in a little further to what's included in the unit is the applicant must submit a unit plan describing how it will be sustainably use the geothermal resource and provide equitable compensation to all impacted owners. This could include a plan for how the geothermal fluids will be produced and re-injected, as well as describing any sort of compensation and how and the processes done there. Of note, the applicant's required to review all existing wells within the unit as well as a quarter mile around the unit. And the applicant must include proof of ownership within the proposed unit. Of note, operators who provide demonstration of ownership of all impacted geothermal resources of a project do not need to apply for a geothermal resource unit permit. So moving on, that's kind of some of the front end stuff of all of the permitting that occurs, as the work is being planned. Let's kind of move into once things have been drilled and are operating, what is still required throughout the project. So similar to how we gather information of as built and as drilled kind of well bores, we'll be doing the same thing. Operators are required to submit location construction reports, drilling reports, stimulation reports, and providing all details of these activities and how this infrastructure was built versus the plan, which is what is on the permit. Additionally, there's logging requirements for all the wells, which provides critical subsurface information in understanding the formations in the subsurface. And with injection wells, there are actually additional requirements to help further characterize the injection wells. And then of note, at the end of the well's life, they're very similar to how we deal with plugging and abandoning oil and gas wells. There are abandonment requirements for all wells in these projects. Additionally, to talk a little bit about monitoring and reporting of fluids, because fluid movement is a very big part of geothermal operations typically in many of the operations. So there is required reporting of all produced fluid and re-injected fluids, as well as any makeup volume of fluid to maintain reservoir levels. There's reporting requirements for temperatures and flow rates at the wellhead, as well as if any reused or recycled water is used within the process. We also have built-in annual fluid usage reporting to kind of have a more holistic look at the year at how the fluids were managed on the site, including the water, any type of water that was used. These are all meant to really ensure we're properly accounting for all water usage, as well as protecting the integrity of the reservoir. Going into some protections and safety, and many of these are somewhat similar to what we've done with oil and gas wells, but some are a little different. There is required mechanical integrity testing and reporting right up front to ensure that the well bore as drilled and completed has proper integrity and is ready to be a part of a project. And then throughout the project, there's ongoing monitoring, which requires mechanical integrity tests and braided head monitoring to ensure there's no leakage pathways in the wellbore, and if any are identified, that they're addressed in a timely manner. There's also requirements for seismic monitoring, especially those that are re-injecting large volumes. And there is both monitoring and reporting required and capabilities to increase reporting and monitoring on the permit. Another kind of unique thing to geothermal is corrosion risk assessment and ongoing monitoring. So in other geothermal plays around the world, corrosion is something to think about and something that is reviewed. And we identified it as something to include in our regulations to ensure safety throughout the wellbore in the system and to identify any corrosion early on to prevent any leaks or failures. There's also groundwater sampling and monitoring to ensure groundwater is not impacted, as well as public water system protections. And then moving into a few more protections and safety. We've transferred a lot of these protections and safety and lessons learned from oil and gas operations, such as signage requirements, fire prevention and protection. In the case hydrogen sulfide is an issue, which is likely going to be very rare. But in case it is an issue, there are protections in place to address any hydrogen sulfide. There is on-location flow line integrity, as well as interim reclamation requirements for, to reclaim any land back after drilling that is not needed for the operation of the project. So moving into financial assurance, with the geothermal wells initially are not going to be by the hundreds or anything. There's at least what we're seeing is quite less of a volume of wells, but there is potential for that to increase in the future. But initially, and we thought this was more appropriate to just have single well and location structure where each well has financial assurance based on its depth. And wells may vary greatly by depth in this type of strategy, anywhere from 3,000 feet all the way to over 20,000 feet. So having assurance by depth is, we thought, was more applicable, as well as $100,000 per location. These are put in place for all financial. The reason why all financial assurance is put in place to protection and liability of the state, and ensure that these projects can be cleaned up even in the event of an operator going out of business. So there is also financial assurance plan requirements, which is our Form 3, and annual and discretionary reviews of the financial assurance plan. And then a baseline requirement is general liability insurance for all operators to ensure that safeguards in place upfront before any drilling occurs. And just to flag a specific part of the rules, the special deep geothermal zones. This is a very local government focused strategy. Through commission hearing and collaboration with ECMC, the local governments can tailor requirements to local concerns and even potentially local technical considerations and community considerations. It always requires approval of both the local government and the commission, and it's intended to create some flexibility in localities that want to either promote geothermal development or maybe want to take a little different strategy in collaboration with us for specific reasons. So that I wanted to highlight that. And with that, I've kind of walked through the majority of the high points. There's obviously a bit more details in there for all of these subjects. But I don't know if Mimi, if you'd be interested in walking through the rulemaking timeline. You're muted.
There we go. Thank you. I'd be happy to. So thank you, Mike, for that overview. I think that was hopefully very helpful for members who are listening in. So with that, I'll walk through now the timeline for the actual rulemaking itself and discuss ways that individuals who are interested in participating in that rulemaking can participate. So as I noted earlier, we noticed the actual rules for rulemaking last week on May the 15th. In that notice of rulemaking, it notes that anyone who is interested in becoming a party to the rulemaking hearing can sign up to do so. So to become a party to a rulemaking, that means that you would have the opportunity to file a pre-hearing statement if you wanted to, a response statement, and pre-filed written testimony for any witnesses that you would want the commissioners to know about and to read their testimony of and present at the actual hearing itself. So parties, again, are able to file papers putting forth their thoughts and comments about staff's draft rules. And you would also have the opportunity then to present your arguments at the actual rulemaking hearing, which will begin on July the 29th. For individuals who are not interested in actually becoming a party to the hearing, but want to ensure that their concerns or whatever feedback that they have about the rules are heard by the commissioners, you can do that by providing us your written feedback or by signing up to provide oral comment at the rulemaking hearing. So what we do in our rulemaking process is we always have a Google form that is put out on our website, usually about 2 to 3 weeks before the actual rulemaking hearing. And that Google form invites members of the public, again, who do not want to be parties, to submit written comment detailing their thoughts about the draft rules. And so you would have the opportunity to do that. There's not a quote page limit to that form, so you can be as succinct or as provide as much detailed information as you think is necessary for the commissioners to have when reading your comments. And I can assure you the commissioners do in fact read all public comment. So for those individuals who do wish to be a party, we are going to have a pre-hearing conference on June the 6th. A hearing officer is assigned to the docket for the rulemaking docket, and they will convene, notify all the individuals who signed up to be a party, the time that we're having that pre-hearing conference. This is a virtual conference. The hearing officer will walk through just the mechanics of how to use our e-filing system, walk through dates that I'm also going to note here for filings, and be available for questions that parties may have. So the first written deadline that we have for written statements is on June 26th, and that's for our pre-hearing statements. And then after pre-hearing statements are submitted by parties, there is the opportunity for a party to file a response statement. And I'm not sure that we captured that on this. Yeah, I don't think we captured that on this presentation, but I can tell you that responses are going to be due on July the 11th. So after pre-hearing statements, you'll then have the opportunity to file a response statement on July 11th. And then we'll have, again, pre-filed written testimony. And the date for that is July the 22nd. So again, pre-filed written testimony is a way in which we seek to maximize the time that is available for the actual rulemaking hearing. So we ask parties to identify who their witnesses are going to be, and to write out what that testimony is going to be. And details about what that looks like and examples and the process will all be gone over by our hearing officer in the course of the pre-hearing conference. But again, it's the pre-filed written testimony is an opportunity for commissioners to have a good understanding of what your witnesses are going to testify to read through that testimony, and then to be prepared to ask questions of your witnesses so that parties don't have to spend a lot of time actually presenting their witnesses in the course of the rulemaking hearing. And then finally is the hearing itself. So again, that starts on Monday, July the 29th, and we hope to have that concluded by that Friday, August the 2nd. That will be a virtual hearing, and we've had many rulemakings virtually, and they have all gone fairly smoothly. So we anticipate that this process will be the same. So with that, unless there's anything that I may have missed, Mike or Ben, I think we're ready to turn it over to questions from members of the public. And please feel free to just raise your hand and we can call on you. It looks like Ms. Burke has a question. Give us a moment and we will promote you and let you ask your question. Ms. Burke,
Good
I think
afternoon.
you, oh, hi
Yeah,
there.
sorry, took me a minute to get re-established. I'm going to ramble just for a sec, and I think the essence of my question is who on the ECMC staff might be best to talk with about questions about sort of the intent and application of the draft. So for example, reading through the draft rules and having spoken with the company that's putting a project together outside of Greeley, I think, they described this project as having a plant in the middle and then up to 4 different well locations surrounding that, pipelines leading from the wells to the plant. And so picturing that in my mind, I'm wondering what of all of that would the rules consider the location? And would those pipelines that run from that well to that plant be considered flow lines, or so that's kind of, because this technology is new, I'm trying to understand how some of the definitions and plans would work with, for example, that proposed project. So anyway, I don't expect y'all to answer that today, but I'm wondering who we could set up a meeting with who could help us work through some of those issues.
Yeah, we would be happy to sit down and walk through that with you. If it's all right, Kate, I think Mike or I will get back to you offline.
That sounds great.
And okay, super. And we'll make sure to get that scheduled here as soon as we can.
Great, thank you.
You're welcome. Thank you. Okay, Heidi Leithwood, give us a moment, Ms. Leithwood, and we'll get you in as a panelist.
Hi, I hope you can hear me okay. There might be some background noise where I am.
You're fine.
Okay. My question is about methane emissions from the proposed wells, whether or not they're newly drilled or if they're repurposed. And what is in the rules about that?
Mike, Sure. I'm not sure if Mike, you might have a response for that.
Sure. So as far as methane emissions, any repurposing of a wellbore would require a thorough analysis of wellbore integrity. So if there are leaks to a wellbore, they would need to remediate those leaks before any conversion could occur. And as far as methane leaking from a new wellbore, these formations that would be targets typically wouldn't have methane in them. If they did, it might be needed to be considered an oil and gas operation if they're actually producing methane rather than a geothermal operation. So it would be a site-specific thing. Now, as far as any emissions, the APCD obviously plays a role in any type of emission sources, but it would be very site-specific, but any conversion would require, like I said, thorough analysis of wellbore integrity. And as far as I'm aware, new wells targeting the target of these wells is not mineral-bearing formations. It is typically water-bearing formations that do not have methane in them. So it would be very low, if no risk of methane leakage in those scenarios.
And the only thing I'd add is even after the well is drilled and production begins, there are still ongoing mechanical integrity requirements. So the operators would be regularly reporting to ECMC that their wells maintain integrity, which includes leaks.
Okay, thank you.
Okay, do we have any other questions? All right, Mr. Moore from Aurora, give us a moment.
There we go. Good afternoon, everyone. Thank you so much for having these discussions today. It's a very great topic, and I'm really looking forward to kind of working through the rulemaking and seeing how it would affect Aurora as a local government and other local governments as well. A couple of questions that have come up as we've been talking today. One of them is on the repurposing. And I'm thinking of a situation where you might have an existing oil and gas well that's reached the end of its life and an operator wants to repurpose it as a geothermal well. But let's say that because it had been producing for decades, it did not meet the setback requirements that are being proposed for like the 2,000 feet for new geothermal wells. What happens in a situation like that? Is it not allowed? Is it an exception that would have to be reviewed by the commission? What would be the procedure for determining if it could be used?
So built into the rules, and maybe Ben can elaborate if I missed something here, is the ability for an applicant to provide justification why it would be within any setback within the rules, particularly if they were going to directly use the heat in a building for heating and cooling, would be a very valid reason to be a little closer to the building because it's more efficient the closer you are. So there's a built-in process to allow for individual site-specific evaluations in that regard.
Okay.
Yeah, I think Mike covered it well. With technical demonstrations at hearing, or with technical demonstrations in the permit application, they can, an operator can demonstrate that it is worth putting it close enough to a particular building. And there are some requirements that the tenants of the building or owners of the building would need to at least be informed and have a say in that.
Okay, thank you. And this other question that I have would be on the form numbers, and I wonder if we might think about either changing the number of the form or perhaps adding another letter, like instead of a form 2A, maybe it's a form 2D or 2G for geothermal, just to kind of distinguish that as they come through the system. I know as an LGD for our area, we get a lot of emails from the commission, which we appreciate, and they're very helpful. But just maybe making some distinction of what it is that's coming through would from the outset would be helpful for our jurisdiction. So I know that you have a lot of forms already, and I hate to suggest adding a new form number totally, but just something to keep in mind.
Appreciate that input, and we have done just that for the 7. We have in the rules a 7G. Our thought process on the 2 and 2A is it would be copying quite a bit of information and then making some adjustments, but I think we can definitely talk through that and contemplate that.
Okay, great. Thank you. That's all the questions I have at the moment.
Thanks,
Thank you
Mr.
so
Moore, for the
much.
input on the form, because that was something that we mulled around a bit, and it's nice to know that somebody else is thinking about a similar issue.
You're welcome.
So it looks like the next individual up is Irene Andrus. Give us a moment and we'll bring you into the meeting.
Hi, yes, thank you. Thanks for this great presentation. I'm wondering when it's a deep geothermal that's going to be actual for power generation, where you're going to have turbines that are turning and things of that nature. What are the requirements for when you're actually going to have a power station there? Who's going to be in charge of those requirements?
So are you talking about like an actual power substation and transmission
Exactly.
lines?
Yeah.
So that is, those facilities are definitely beyond the ECMC's regulatory authority, and it would include the either the PUC likely, and maybe local authorities depending on the situation, and they would be but so those types of power distribution lines or even transport lines are not under our jurisdiction. We did not make it.
Well, will the hearings, when you have public hearings, will it also involve, like, will both parties be there to explain the impact on the community?
I think that's a good flag, and we could look at potentially bringing some of that into our consultation process. But as it is, the operations don't assume that it's going to hook to a grid, because many of these situations won't.
Right.
Only the largest of plants would be hooking to a grid, and there would be power purchasing agreements in place through like, somebody like Excel, as well as like stipulations from hearings and things that the PUC would be running. So they would likely have much more information on how that works than I do.
Okay, hey, thank you.
Of course. Mr. Sura, we'll bring you in now. Give us a moment.
Yeah, thanks for this discussion. I have a couple questions. The first one is on this idea of oil and gas well that is going to be reused. Wouldn't that require significant changes to infrastructure on site and therefore typically trigger a Form 2A, location assessment?
I think potentially, yes, that could definitely happen if there is significant disturbance to the location. A 2A, an amended 2A would have to be submitted and approved.
Okay, and right, I might suggest that, that be described in the rules because I think it'd be helpful. And then the other question is that it appears to me that there is some allowance for an operator of a geothermal well to force themselves onto an unwilling landowner by bonding on. And I'm just curious as to, one, why you think that might be necessary, and how that might affect somebody that has got an existing well on their property, looking forward to having it be plugged and abandoned, and all of a sudden, being forced to accept that it's now being turned into a geothermal well and having another lifespan of another 50 years.
By bonding on, do you mean like unitization and pooling?
It was there's a surface owner bond for those surface owners that don't have a surface use agreement or a lease, and that would indicate that you're allowing for these wells to be drilled on someone's property or repurposed on someone's property without their permission.
I see. Go ahead.
So, and I'm sorry, just so I make sure I understand the scenario. So, Matt, are you saying for instances where it's been an oil and gas well where there was not a surface use agreement and the operator bonded on in order to drill the well and then seeks to repurpose that well for geothermal purposes, is that an allowable continuation without engaging the landowner into signing a surface use agreement?
Yeah, so the
Is that
service
the
use
scenario?
agreement, so the service use agreement should be, in my opinion, should be required in both instances, both with a new well and a repurposed well. But according to the proposed rule 1316C2C, they're not requiring surface owner agreement for these new geothermal wells. And I don't see a justification for that. We're talking about geothermal resources, which are located broadly in an area, and you shouldn't have to force your way onto an unwilling landowner.
There is one item I'll flag with that, and I would want to say we can look further into this too and read through some more additional items, but I would flag that the geothermal resource is by default the resource of the surface owner. So there will be, and I'm unaware of major kind of, let's say, acquisition of those rights like we have in minerals, like split estates. So there is that kind of immediately that comes up that would prevent some of that, of what you're talking about. But I want to kind of look further into this myself and talk, and we can kind of maybe get back to you on that with some additional details, unless Ben or Mimi have some additional thoughts there.
I was just gonna say, other than what Mike just said, thank you to Matt, because that's an interesting scenario that I don't think we delved into too deeply. But it is one that needs serious consideration. And I know that there are situations in the state where there are surface owners who don't necessarily want wells there. And so, yeah, that's something I think we can think a little bit more about as we approach the hearings. So I would say thanks for flagging that.
Thank you.
Okay, do we have additional questions? All right, give us a moment. Sir, I don't think I'll pronounce your name correctly, Mr. Sars. Give us a moment. We can see you, Mr. Sars. If you would like to unmute, we'll be able to hear your question.
Okay. Just a question about the geothermal, was it the resource units, and how owners of the geothermal heat are considered. I assume they're considered based on surface property. The question I have is, when a geothermal operation establishes a flow field, is that the outline of that flow field being considered, and is the operator required to report the limits of that flow field?
Yes, so how we have it in, and thanks for that question, Matt. So how kind of the rules have it contemplated is that all impacted owners. So that, depending on your type of project, could be a small project in a small area, but if you do have, let's say, long reach laterals circulating over a large area, the operator would have to provide technical testimony supporting the unit boundaries and their extents based on actual technical analysis. So will be a site-specific review of what are the appropriate and who are the impacted owners of the project and whose heat's being utilized. I hope that answers your question.
Yeah, I just know that we've gotten that question in the past, so thought I'd just make it clear, and I think your answer is clear. So thanks.
All right, next up we have Mr. Moore from Aurora again. Give us a moment and we'll bring him in.
All right, thank you again, Deputy Director Larson. Thinking about operators, I'm wondering, would a geothermal only operator, are they going to fall under all the normal rules and regulations for an oil and gas operator in the state, or are there going to be separate rules and regulations for geothermal operators? And I'm thinking especially in terms of financial assurance and bonding. And then, of course, down the road, are we thinking towards creating a structure of what does a low producing geothermal well look like? Now I'm thinking really far in the future, but eventually geothermal wells might be no longer producing, and they might have the same risk as we see in oil and gas wells now, where operators could potentially have the opportunity to walk away from them if the rules aren't stringent and try to prevent that. So can you talk a little bit about the thought process around those, how operators are established for geothermal, and are there going to be differences, or will they just be considered a regular operator?
I think that's a great question, Mr. Moore. So I would say generally the default is deep geothermal operators would be considered generally similar to oil and gas operators, except as the 1300 series specifies otherwise. And you pointed out one good example, which is financial assurance. So the way financial assurance works for deep geothermal operations is similar to oil and gas, but slightly different. So for example, in the context of deep geothermal, there is a single well cost, plugging and abandonment cost based on depth, and no provision for what is sometimes commonly referred to as demonstrated costs, as we've seen with oil and gas. But then in other instances, they're treated the same way, which, for example, the general liability insurance is still $5 million across the board. So the way we're generally thinking about these rules working is an operator goes to the 1300 series, or any interested party goes to the 1300 series, and you can read through the 1300 series and see everything that applies to deep geothermal operations. And then we list out rules from other series that are incorporated by reference. So those rules that are incorporated by reference are meant to operate as similarly as possible in the deep geothermal context as oil and gas, which is why, kind of circling back, I say the sort of default is thinking of deep geothermal operators similarly to oil and gas, except where the 1300 series specifies otherwise.
Okay, thank you. That's very helpful.
Thanks.
Okay, we have about 5 minutes or so left. Any other questions? Well, not seeing any. Again, thank you for your participation this afternoon and seeking to learn more about the geothermal rules and our rulemaking process. One final note, the information about the draft rules, how to sign up to be a party, all of that can be found on the ECMC's webpage. Under our news and notices, we have a description with links that will take you to the page that has our draft rules and that sign up form to be a party. Also, if you go to the hearings page and select the rulemaking tab, you will also be able to navigate your way to the geothermal rulemaking page. So with that, we'll close out the meeting and wish you all a very great Memorial Weekend. Thank you.